Please be seated. We are back, and our next case is U.S. Bank versus Java. I hope I pronounced that correctly.
Good morning, panel members, and may it please the court. My name is Benjamin Brown, and I, along with my co-counsel Julie Wishmeyer from Burleson Brady, represent the appellant U.S. Bank as trustee in this case. Before I begin, may I please reserve 5 minutes for rebuttal? Thank you.
Let me ask you something right out of the box. I know we have a singular borrower, but we have what appears to be two separate loans going on two separate tracks through two different financial institutions.
Yes.
And okay, go ahead.
Yes, and essentially this case arises out of a 2006 refinancing transaction. And in 2006, my client's predecessor, Synovus Mortgage Corp, originated a approximately $1.5 million loan that was intended to pay off and satisfy a 2004 loan, also to borrower Paul Jallo, and that prior loan was for $2.3 million. It was actually an open-ended line of credit.
But the payoff language is in the settlement statement, which is only executed by Mr. and the title. And you have title insurance for any breach thereof. I don't see what you're complaining about. It's any relationship between Synovus and U.S. Bank, or otherwise it creates any breach.
Well, I think for starters, we've identified and asserted in our brief that that the standard and the pleading standard in this case for asserting a cause of action in negligence is, of course, very simple and very straightforward. And to that end, I think even in our reply brief, we identified the Florida Supreme Court approved forms for vehicular negligence, fall down negligence, and other types of negligence. And of course, it's all very rudimentary.
To contractual documents such as the note, mortgage, settlement statement attached there too, and the sound of the breach of contract. If you don't follow breach of contract, which the independent court will apply to, but if all of your allegations alleged by implication contractual duty.
Well, and if I can just sort of pick that apart piece by piece. First of all, to the extent, because when we saw the motion for summary judgment, which, by the way, came along at an unusual time because the motion was filed before the pleadings were yet closed. The rule does not necessarily, again, the rule does not forbid it, but if you do file a premature motion or you do file a motion before the pleadings are closed, the heightened burden applies. And
how do you answer? How do they answer?
Well, they did. Synovus did file an answer to which
they
we
could
reply.
file a motion for trial. Correct? It's an issue.
Well, once the pleadings are closed, once the reply is filed, once the reply is filed.
Okay.
But to answer your other question, yes, we asserted multiple causes of action against multiple parties. However, one thing that we make clear throughout our pleadings, and we attempted to make clear to the trial court at the summary judgment hearing and thereafter, was that we only asserted one cause of action against Synovus Bank, and that was for negligence. We never alleged the existence of a contract with Synovus Bank. And that is the a chasm of difference between several lines of cases that are argued in the briefs. The Tank Tech case, the Peoples versus Pewitt case, because from our perspective, we only had that singular cause of action in negligence or tort.
Are you a third-party beneficiary of this agreement?
Of which
The
agreement?
whole, the first mortgage, correct?
Of Jalo's 2.3
You're
million?
arguing that Synovus had a duty to pay out the first mortgage, correct?
Yes, a
Okay, so
statutory
you're a
duty.
third-party beneficiary of that contract between Synovus and Jalo.
We're not asserting that, and
Why not?
well, even if we did hypothetically, the loan documents between Jalo and Synovus are only an obligation to pay a debt. It would not, I mean, effectively, we would be a recipient of additional funds if we were an intended third-party beneficiary. Well, I think for starters, I don't believe that issue was briefed by Synovus or argued by Synovus at any point in time. But what it boils down to is that Synovus, points to, the independent tort doctrine and says, oh, this is barred by contract. But the case law that stands for that proposition, the Peoples versus Pewitt case, which is very distinguishable, it applies in situations where it's the same party with whom you have a contract. If you have, if A has a contract with B, A can't sue B in tort for a wrong that is covered by the contract. That's exactly what Peoples versus Pewitt is all about.
Okay, so you eliminate that, but the other reason you point out. But then you still have to explain what gives rise to the duty of breach for now. There's no contract, so there's no contract, therefore this isn't barred by the independent tort doctrine or non-glossal or whatever. So, okay, so where does the duty arise?
Well, the duty to arise, for instance, first of all, on summary judgment, this is a summary judgment case decided under the old standard, the scintilla standard, and it was Synovus's burden and duty to show to the summary judgment standard that no duty of that law could exist. They did not do that, and it was and we had indicated in our pleadings, which our reply even indicated the exact statute, but 70103 and 70104.
But that is, if I'm wrong, that duty doesn't exist between in the relationship that these two parties, U.S. Bank and Synovus are. That duty is a mortgagor has a right against a mortgagee. That's not the relationship.
I would disagree with that, and here's why. 70103 and 70104, when you look at them, first of all, they're plain language. The plain language of the rule does not limit their application to any class of person or persons. It does not limit their application to a mortgagor, that is the borrower. And the way that 70103 and 70104 are set up, 70103 is essentially one that is, now I would concede this, 70103 is drafted in a way where it is more for the benefit of the borrower or the mortgagor, because it says that upon full payment that the lender, the mortgagee, has an obligation to cancel the instrument. That would be the note.
But that's for the protection of the borrower.
I would agree that 70103 is more for the protection of the borrower, and that's why I'm sort of I pivot to 70104. 70104 is much broader, and again, the plain language of 70103 and 70104 makes it clear that the class of persons protected, but is not limited in any way. But 70104,
I'm having a hard time understanding how that gives rise to a duty to a stranger to lend a transaction.
well, 70104, and again, the reason that there's not just one statute and then there's two, 70104 is set up and separated from 70103 because 70103 is more for the benefit of the borrower and the cancellation of the note. 70104 is about the cancellation of the mortgage in the official land records. This is about the protection of parties, who may be inspecting the public records at large. And this is to prevent, third parties from coming along and claiming, BFP status. That's what 70104 is about, and that's why there's a requirement that there's the satisfaction that's recorded in the public records, within 60 days. And, incidentally too, and I know that this was briefed, but we know that this was an issue with home equity lines of credit in particular, because in 2016, the Florida legislature changed the statute. They changed the statute to accept out home equity lines of credit or lines of credit mortgage. But at the particular point in time, that is 2006, the prior version of the statute applied, and a statutory duty that was not limited to any class of person or persons was present on the Florida statute books, which would have obligated Synovus Bank to pay off and satisfy that line of credit mortgage of record. And
Right, it probably shades into the statute of limitations. I don't necessarily want to go to statute of limitations, but the fact is, you knew that it had not been satisfied of record.
I'm not sure, that hadn't been established.
Okay.
That hadn't been established. And again, I won't belabor the record and how exactly the motion came about. But again, the motion was filed without any supporting evidence.
Well, so, we're going to assume for purposes of their motion, the summary judgment motion, that everything in the complaint is true. I mean, maybe it's more akin to a motion on pleadings or something, but I mean, we're accepting the facts of the complaint.
Understood. And that is even considering Synovus Bank denied, the vast majority of allegations in the complaint. But under that assumption, in review, there's no question here in this case that Synovus received all of the money from the closing, over $1.4 million. They admit that they received it. I mean, that actually was an admitted allegation. Then, in between the time they filed their motion and the time of the telephonic hearing during COVID, we took a number of depositions, several, I believe 3 representatives of Synovus Bank. And one of the individuals testified that although a payment history was unavailable for inexplicable reasons, the payment history should have been available because the loan was sold later. That's normally something that's required or provided along with the loan sale. But the transaction journal or ledger was available, and it showed that at the relevant time, my client's predecessor's money was paid in, received, paid the loan down to 0, and the loan remained at 0 for approximately 10 months.
Does that create a legal duty? Somebody put that in the payment? But still, in their answer, denied a legal duty and argued they did not have a legal duty.
Well, but
whether or not Synovus paid it or not, is that material?
The answer is yes. From our
This is a
perspective,
legal issue?
well, I guess a few different pieces to unpack there.
No, the duty is a legal issue, correct?
I agree that the existence of a legal duty
And
is,
so a deposition of somebody trying to recall based on lack of record, they're trying to recall something, so we'll pay it off.
well, I think that it goes a little, past the issue of duty. I believe that the duty, is set, by virtue of 70104, and quite frankly,
But you didn't make a written request for the, by a mortgage loan. That's a condition precedent. If you file a lawsuit under 70104, you've got to pledge conditions precedent were completed, which one of which is subsection 1 within 14 days of written request by a mortgage. You didn't do that. You haven't done that in this case.
well, I
How does 701 apply? I mean, that's the first sentence.
well, and again, there's, I guess, a couple of different issues there. Is, number one, that was not an argument that was ever advanced by Synovus Bank in its motion or in the hearing or in its brief.
Well, then how did you comply with 70104?
Well, we filed an action in negligence,
Right.
citing 70104 as the relevant standard.
Alleged was Synovus Bank had a duty to properly apply funds received to pay off close and satisfy the prior mortgage. You never cited 701, you
Well, from our perspective, we didn't need to, for the reasons I mentioned before, in terms of what the pleading standard is in Florida. I believe we addressed this most carefully in our reply brief. About the bar is low in terms of what is required in order to state a cause of action for negligence. Erring on the side of caution after seeing Synovus's motion for summary judgment, where they highlighted that there's no duty owed to Synovus, or that, et cetera, something along those lines. We even filed, out of caution, a motion for leave to amend complaint along with a proposed third amended complaint with buttressed and fortified and clarified provisions regarding duty and, from and to. And I believe that was filed sometime between June 29th and the time of the hearing, August 25th.
Mr. Brown, let me interrupt you for a moment. You're a little bit over 15 minutes into your argument. It's your time, use it as you wish. I just wanted to give you a heads up.
Yes. Well, I'll just finish up with this issue, and then I'll reserve the remaining time for both. But the bottom line is, so number one, from our perspective, we adequately stated a cause of action for negligence in our second amended complaint. Second of all, we even filed a motion for leave to amend complaint and attached a proposed third amended complaint with fortified, buttressed, clarified provisions regarding duties. In response to this potential argument by Synovus that duties were not adequately pled. At the hearing, I believe in the transcript, the judge made it clear that this was not a pleading issue, the pleadings were fine. And then in the judge's summary judgment order, not the final judgment, but the summary judgment order, Judge Allen also reiterated that this was not a technical pleading issue. And again, I believe that to the extent there ever was a pleading issue, we protected ourselves, and the court could have and should have denied the motion and granted us that leave to amend, and allowed us to plead with the third amended complaint, but we never even needed to, because the court, decided that our pleadings were adequate, with respect to the negligence cause of action.
Is that really what she found? Because the court can simply say that the pleadings are adequate for me to make a rule, as opposed to the pleadings are legally insufficient. And Judge Allen said, the argument misses the point. Before the court is not a technical pleading issue. She fully understood that you had no contractual relationship with the plan, and you owed no duty to the plan. Under the circumstances played by the plan, so it was supposed to be So it looks to me like Judge Allen reviewed pleadings and specific allegations and found that you did not establish duty based on the totality of the pleadings.
And I think I agree with you insofar that Judge Allen found that there was no legal duty, that there was no pleading issue. I think in my understanding and my reading of her ruling was that we adequately pled everything we needed to plead, but she simply found that under the circumstances that there was no legal duty of Synovus Bank, to pay off or satisfy the mortgage under the circumstances. So with that, I'll leave my remaining time forward.
Yeah, we'll give you 3 minutes.
Thank
Thank
you.
you, Mr. Brown.
May it please the court, my name is Nicole D. Newland, and I'm here on behalf of Synovus Bank. I think this panel has asked several questions about duty, and I think Judge Allen's order is very clear that she found that there was no duty. She did analyze it in the context of 70104 as well as more of the common law duty, and specifically found that there was no relationship between the parties in contract or otherwise. And I think that that is consistent with the prior case law that says in these situations where there's purely economic losses, that there has to be that relationship or an extraordinary circumstance. And that wasn't present here. In fact, Judge LaRose brought up at the very beginning, these are two separate transactions kind of running parallel, right? For purposes of our transactions, our successors in interest were Mills and Crescent Oaks. For purposes of the appellant's transaction, it was following Synovus Mortgage Corp., which was not a related party. So these were two separate transactions, not even in the same row, for lack of a better word. I think that Judge Allen also said it well, and I've got her highlighted here. She stated that in ruling on the issue of duty, that it would be a generalized, never-ending duty to any subsequent holder of a mortgage on real property if she found a duty in this case. Plaintiff's negligence claim, if allowed to proceed, would essentially make Synovus a title insurer for any party having a subsequent interest in the party, either as an owner or mortgage. And I think that spoke volumes about that issue of duty. But as we've discussed, there were three separate bases for the order, and Judge Allen found that there was no duty, and you can affirm on any one of the three. But there's also a statute of limitations issue, and we haven't really discussed that issue yet. As Judge Allen found, she determined that the statute of limitations began to accrue in March of 2014. There was an attachment to the complaint, and it was an email from the appellant to the title insurer, and it stated, a review of title reveals an open senior HELOC in favor of Mills 2011 LLC by virtue of assignment of mortgage. It then demands coverage and indemnification under the title policy. Judge Allen determined that that March 2014 email was when, at a minimum, the statute of limitations accrued, because they knew they were damaged. Now, there's been extensive focus in the briefing regarding concepts of professional negligence, and in those cases where this court and other courts, quite frankly, have allowed that to be extended in certain circumstances, particularly in cases involving lawyers and an accountant, right? Judge Allen determined correctly that those cases didn't apply here. And I think she relied on two cases that I believe are really important. One of them was Keller Mayor, which is 427 Southern 2nd 343 from the first DCA. The court in that case found that the party suffered damages, and it was a very similar as you can get case. They determined that the party suffered damages when the funds were diverted, not when the priority of mortgages was determined, which is what the appellant has argued here. Their argument is, we didn't have damage until the lower court, or in this Crescent Oaks foreclosure, this subsequent foreclosure action, until they said, your loan is second and we're foreclosing. And in Keller Mayor, the court said, although the exact amount of damages may not have been established until the foreclosure action, the statute begins to run when there is injury, however slight, even if the full extent of the injury is unknown. And it says that when that loan was impaired by the fact that it was second, or whatever the case may be, that's the damage. There's an immediate diminution in the value of that mortgage because of being no longer being first. And it didn't require the foreclosure action in that case. And in this case, it doesn't require the foreclosure action. In March of 14, appellant knew that this action, that there was an unsatisfied, or at least an open HELOC that previously had been associated with us. There was damage. Now, ultimately, the foreclosure court determined that their loan was second and foreclosed their interest. That may have impacted the amount of damages, but that there was already damage. So I think the concept that I wanted to focus on, as it had not been previously focused on, was this concept of the statute of limitations. If it accrued in March of 14, that statute of limitations ran in 2018. This action was not filed until June of 2019. So it was filed beyond the 4-year statute of limitations that are applicable to negligence actions. The other concept, and this court did discuss the concept of duty. Just briefly, I want to focus on a couple of those issues. I believe that Judge Allen's order was correct in the regard that she found that there was no duty. She did state it was not a technical pleading deficiency, and she did go ahead and analyze 70103 and 70104. Now, obviously, there's also extensive briefing on this issue. The appellant in this case was obligated to plead ultimate facts that supported their claim for relief. Their argument is we didn't need to plead this statutory basis to get the relief under the statute. I disagree. Now, they have stated, and they've compared it to comparable automobile accidents, and they say, you were in an automobile accident, you don't have to plead the statute that creates this duty under automobile law, right? That's the argument. My point is, you have to plead the relationship of the parties in order to plead the duty. If that duty is created by a statute, that should be pled. That duty in that statute, this court found in Shelton, which Judge Allen cited to, this court actually discussed 70104. And it said, and this was the Washington Mutual Bank v. Shelton from 2005, the rule of strict construction has been specifically applied to section 70104. Under such strict construction, 70104 would apply only to the mortgagor. Further, even were the statute extended to a junior lienor who pays off the first mortgage, the Sheltons make no contention that they did not obtain a timely estoppel, et cetera, et cetera. And then it goes on to further discuss 70104. Now, there's also a third DCA opinion, and that was cited in our motion for opposition to the motion for rehearing. And it's Laza Inc. v. Wells Fargo Bank. And the court stated in regard to section 70104, there's little doubt that Florida recognizes such a separate and discrete cause of action by a borrower against a lender. Undoubtedly, in this case, appellant is not a borrower. There was no allegation of the conditions precedent having been satisfied in the complaint. There was no allegation that 70104 was even at play until they filed the reply. Now, I do want to make the comment because this came up in the briefing as well. In the reply to our affirmative defenses, there was an assertion that's the first time that we saw 70103 and 70104 mentioned. But it doesn't mention duty. It says, defendant failed to lessen the risk to plaintiff and failed to take the necessary precautions in order to protect plaintiff from harm and damages. And they cite C, 70103 and 70104. But there's no mention of duty. So then they argue, well, that's not our fault that you didn't know. Well, it is, because there's obligations under the pleading rules to plead the ultimate facts. And if the basis of the duty in this case is statutory, they had an obligation to indicate so. Now, Judge Allen didn't go there. She found it just didn't work here. She just found it didn't apply. So this court could affirm on that basis, or it could affirm under the grounds of the statute of limitations that Judge Allen determined. There's also the issue of the independent tort doctrine. This court has indicated in prior questioning that it believes that there does have to be contractual privity. I will inform this court that in the Peebles v. Quigg case, which is the case that was relied upon by Judge Allen, there was not contractual privity. The parties in that case, it was a contract between Quigg and then two entities called PABC and Collins Avenue. Quigg sued for breach of contract against these entities and then also sued a woman named Peebles for the same damages. Peebles did work for one of those entities, but the contract wasn't with her. So there was no contractual privity between those entities. Nonetheless, the court said that because the damages that were being sought by the contractual relief were the same as the tort damages, that the independent tort doctrine controlled. And that's the case that's cited by Judge Allen in her order. For where that's headed. The other points, I don't know if your honors want me to highlight any of these issues, but I know that they discussed our reliance on the summary judgment on the complaint as the merits of the complaint, on the truth of the complaint, and we did not provide any summary judgment evidence. I believe that the rules clearly state that you're allowed to do that. In fact, in the Green case from the first DCA in 1993, an unsworn complaint must be accepted as true for purposes of a motion for summary judgment unless conclusively disproven. We opted to accept that it was the truth for the purposes of our argument, and so there was that. There was also a discussion in the briefing about discovery issues that remained pending at the time of the hearing. And I believe these issues have been fully briefed for the court, but I wanted to make a quick point on that. There was not a request to continue this motion for summary judgment when it was set for hearing. I did cite several cases in the brief that dealt with that. There's nothing in the rule that specifically said that at the time, but the case laws repeat with examples. Subsequent to filing my brief, I found additional case law that says the same thing. And it says something similar to this: failure to request a continuance of a summary judgment hearing precluded review of issue whether defendants had reasonable time to complete their discovery prior to the hearing of the motion. In this case, even if you can construe the comments at the summary judgment hearing indicating that there was some discovery which remained as a request for continuance, there was no affidavit ever filed explaining what the relevance of this discovery was. There was no information provided as to what attempts had been made to procure the discovery. In fact, in their brief, they state, there was a payment history that they wanted, but then they readily admit that Synovus says that they don't have the history. There's no testimony. There was nothing provided to the trial court or even subsequent that was sworn that said, why is this evidence relevant? Does it exist? This was the failure to have, it's not the result of an inexcusable delay. There was nothing. And so I think that was an important consideration that this court should consider. So absent any questions from the panel,
Thank you, Ms.
I will conclude. Thank you, Your Honor.
Mr. Brown?
Yes, may it please the court. Just to touch on a few points that were made before, with respect to 70103 and 70104, we cited one case in our brief, the Cheshire versus Magna Carta case, the second DCA case from 1987, and it stands for the proposition that the court may not grant summary judgment on any extraneous matters or any matters that are not set forth in the movement summary judgment motion. And all of the briefing about 70103, 70104, and the discussion today, it all falls under that category because the court entertained these issues. But again, the statutes which were directly on point were not cited by Synovus in their motion. And the only motion that the only case or authority they cited for a legal proposition about duty, related to, I believe it was a city, and it didn't, involve two different banks or a refinancing transaction. So, from our perspective, this line of cases would govern and would require reversal because the court entertained argument and decided. The motion for summary judgment is very clear on one of these bases of duty, finding no duty under the statute. The statute didn't apply. Was one of these matters that was not briefed by Synovus in its motion. Also, the Wills versus Sears Roebuck case, I believe that's the Florida Supreme Court case, that case makes it clear that on summary judgment, it is Synovus's duty to unequivocally show that there was no negligence in this case. We believe that they failed to do that.
The statute, so and I was reading this Washington Mutual versus Shelton, and it seems like it was trying to consider wiggle room about who would bring the action. Even if it was, I guess, June Winter. in order to be, if you're the mortgagor or a person who has fully paid an outstanding mortgage in your judgment, you actually need a statute, apparently, to bring a cause of action to require satisfaction. But your client's not even a mortgagor or a person who has fully paid an outstanding mortgage in your judgment. And you're saying that this statute somehow confers a duty to your client?
It sets forth, and again, one of the issues, again, that the court decided without having, Synovus having moved forward, was the fact that the court decided that this was a standalone private cause of action that we should have brought instead of our cause of action for negligence. Obviously, we did not bring a statutory cause of action. We brought a cause of action in negligence. And as I mentioned too, yeah, the cause of action for negligence may be caused by somebody running through a red light or a stop sign, and there's a statute that forbids that. But you don't necessarily need to plead that statute in your complaint when you plead that an individual committed vehicular negligence against you. The law doesn't require that.
I guess I'm just trying to figure out who is U.S. Bank in this scenario?
U.S. Bank is
In
the,
generic terms,
yes, I mean, they're
they're not a mortgagor.
they're the mortgagee of the 2006
Right.
mortgage. And again, going back to the
So
Shelton case,
What duty is owed?
Well, we believe that under the language of 70104, it's very clear that it's broad and that it protects the public records, and that it would include and encompass mortgagees as well. Because obviously, if there's a satisfaction of a prior loan, that would protect a subsequent lender and their priority. And this is an issue of priority, and that of course flows into the statute of limitations issue too, because when Synovus Bank received full payment of its loan was paid zero. The statute requires that they pay it off. Our closing instruction said, our loan proceeds should only be dispersed if there's, if we have priority, there's no other lenders out there. At that point in time, Synovus had a duty to pay off and satisfy that mortgage of record. And without doing that, then there's a question of priority, because then you have two mortgages of record. And it wasn't until and unless our mortgage, the trust or appellant's mortgage, it wasn't until our mortgage was extinguished in the 2015 foreclosure case that that priority issue was established.
Mr. Brown, you have to wrap up, please.
Yes. So for those reasons and the reasons that we detail more closely in our briefs, we believe that the summary judgment order should be reversed. Thank you.
Thank you very much. Thank you both. Our final case this morning is Progressive Select versus Kagan Jugan. Ready when you are.
Good afternoon, Your Honors. May it please the court. My name is Michael Clark, and along with my colleague Jennifer Emerson, we represent Progressive Select Insurance Company. I'd like to reserve 5 minutes for rebuttal. The relief we're requesting here from the court today is to reverse an order denying attorney's fees to Progressive Select under a proposal for settlement, with the trial court concluding that it had not been made in good faith.
So the one summary judgment based on the MRI case, and then the judge found it was in bad faith based on the great public awards and the Supreme Court taking jurisdiction over the same case.
Yes, Your Honor. It is somewhat incongruous. The basis as expressed was that there was an unsettled, the argument that was advanced by the opposition, there's an quote, unsettled status of law, therefore it would not have made the space. But the language of both the final judgment granting Progressive, its motion for summary judgment was based upon this court's opinion, as authored by yourself, with your colleagues, in the MRI Associates case. And then in denying the rehearing of that final judgment, the trial court indicated that it was bound to follow the Tampa MRI Associates case. I included within my appendix the jurisdictional order from the Florida Supreme Court. They found that they're not going to decide the case, at least on the basis of any conflict jurisdiction. They may review the issue of great public importance that's there. They also may not do anything. They may discharge the writ.
Yeah, the trial court's ruling is subject to an abuse of discretion.
It is indeed, sir.
Is it possible that the court, on the merits of the claim, felt bound by the case? But recognizing that it is an issue that the Supremes may weigh in on, thought $50 offer of judgment just didn't cut it.
Well, but I think the test is, was there a reasonable foundation to make the offer at the time, or I'm sorry, the proposal at the time that it was made? And the facts show that the law in the state of Florida had clearly established, not only through the orthopedic specialist case opinion, your opinion in Markley Chiropractic, the opinion that you authored, and by the time, again, Tampa MRI Associates decided before the service of the proposal, that's the reasonable foundation. We can't have any uniform jurisprudence in our state if we are allowing trial courts or other courts of inferior jurisdiction to ignore binding precedent. And that's what this is.
But it can be, if the court was required to follow binding precedent, ipso facto, there was no possible wiggle room on whether your claim will have any weakness that would suggest that you should have, in good faith, tried to dispose of the litigation, as opposed to a conclusion that you just, all you're trying to do is get paid. In other words, that's the other extreme you're kind of proposing. Like, well, hey, the court said I was bound, so therefore we obviously had a rock solid case that permitted us in good faith to say we'll give you nothing, pretty much.
Well, now you're
That can also be the rule.
well, I'm sorry, you said that can't.
That's the other polarity. It sounds like you're suggesting.
No, what I'm suggesting is the entire purpose of the proposal for settlement statute is to make people take a very close look at their case before they continue litigation.
And the trial court thought, well, you didn't take a good look at your case, because even though
Trial court thought the plaintiff didn't take a good look at their case. Because again, then let's look at the facts of the procedural posture of the case before the proposal was made. The complaint.
well, wait, maybe I'm twisted around here, but you're saying this, the trial court thought that if the proposal wasn't in good faith, which leads me to believe the trial court thought the one making the offer of judgment had not taken a good look at its case.
Yes, I agree with that statement. Yes, based upon Wagner versus Brandenberry, the trial court concluded that there was no reasonable basis for the offer that was made. Yes, so I'm sorry.
My point was that you're saying, it sounds like what you're saying is that, well, since the trial court ultimately decided that it was bound by case law, that must mean that the offeror's case was absolutely rock solid, such that it could never be, no aspersions could be cast on in good faith if they offered essentially nothing.
No aspersions can be cast upon the idea that there was a reasonable foundation to make a nominal offer. Because nominal offers are made all the time.
So anytime, but that's just saying, anytime you win,
No,
we can make a nominal offer and it's in good faith.
No, it has to
Because
be.
why do you usually win? You usually win because the law's on your side. So because the law was on our side, therefore we had a good basis, therefore we had good faith, therefore nominal offer meets the good faith standard.
We're skipping a step.
Okay.
We're skipping the step of what is the basis of that reasonable foundation to allow the nominal.
Well, let's get it.
Okay,
Say, why was your notice ironclad under?
I'm happy to answer that question. The complaint was filed in April of 2018, very clearly a breach of contract for underpayment of PIP benefits. Crystal clear, the issue is, should they have paid at 80% of the amount charged, or should they have paid according to the schedule of maximum charges? The answer was filed with a very clear and affirmative defense saying that we've done everything that we've needed to do. Our policy has provided sufficient notice. These are things that have occurred before the proposal has been served. Then we serve our motion for summary judgment. Single issue of dispositive law, matter of law only, interpretation of the statute and the policy. And we support that by an affidavit that establishes that this is a policy that was in effect and supplies a payout sheet, which shows what we paid, how we paid it, and paid it according to the schedule of maximum charges. Still, no proposal of settlement served. So at this point, we've now have the complaint at issue. We have the motion for summary judgment filed, and we have a supporting affidavit that authenticates the policy as well as the payment methodology that was at issue. We go so far as to begin to rely upon the Allstate, the orthopedic specialist case and identify that. By that time, this court had decided both Tampa MRI and had decided MRI Associates and had decided Markley Chiropractic. So those things are out there as binding issues of law. Then we serve the proposal for settlement. And that the examples that I used in the brief, and I will go to them right now, they occur all the time in contractual obligations when you feel that you have no exposure under the contract, which is what the position that we were taking. And I cited two cases for
this. I call you. I'm just curious. Is there room for the idea in all of this that if I know you cited it, ample authority that nominal offers are not per se bad faith. Is there any room for the thinking that, well, even if you think that you have absolutely positively no liability on the current case law, that if you don't even make a good faith effort to try to support the baby, then all you're really doing is setting yourself up for these.
That's not what the statute is designed to do. The statute is designed to terminate litigation. That's what Progressive wanted to do.
The other purpose is to say, I want to let you know that you have no case. And if you proceed further, you're going to be left.
Progressive laid all their cards on the table at the very inception of this lawsuit, before they filed the proposal, based upon an application of binding authority. Had they
So the
accepted
standard is not whether you were really. So I mean, in this case law, there's talk about the public policy underlying the statute and what is the public policy. What you're saying is, also what the case law says is that good faith is merely an assessment of whether there's a basis for your offer and whether it has any relation to what the strength of your case and the relative.
That's what this court has said specifically in Wagner versus Bradner. And it's part of the whole. And again, let's make no mistake here. The provider or the appellee had the ability to accept the nominal offer and run no risk of an attorney's fee. Okay, so this is not getting Progressive is not interested
or
in
voluntarily dismissed.
Or voluntarily dismissed, or even before the summary judgment hearing, which occurred in January of 2019, months after, they still could have stayed out from the threat or the specter of an attorney's fee award by dismissing the case, as you've indicated. And by then, the law was so favorable to Progressive's position on the facts, and recall the record will show, there was no opposition to the motion for summary judgment at all. There was-
Let's pivot to discretion, which the abuse of discretion standard is so wrong. We have to find that no other judge, no other trial judge would have done this. Agree with that? So,
No, yeah, yes, I
no other,
do.
no other legal trial.
Yes.
But if you look at 7A, 769, 7A, and 7B. So 7B, I get it's triggered when you determine entitlement. And then that's mandatory, which you got to consider. But if 7A says it's up to the judge's discretion to determine whether it's made in good faith, what precludes the judge from going down, looking at 1 through 3, but also there's case law says the judge can look at strategy, status of the law, whether the offeree or the offeror will waiver from his or her strategy, can assess the logic and strategy in case whether there's a reasonable foundation. Then there was another case where the offeror took the depositions of certain witnesses and found the case had no merit whatsoever. So if the trial judge can consider all of that in determining under 7A whether it's made in good faith, why can't he or she determine under 7B 1, 2, 3? I understand it seems incongruous, like you said, but the Supreme Court had accepted jurisdiction on Tampa law, and this particular judge, believe Judge George that the unsettled nature of the case. I mean, is that abuse of discretion? Consider said the judge abused discretion because he ignored the fact that the Supreme Court took it up. Question very important.
Yes, it is an
And
abuse
they
of
could
discretion, especially for the reasons that he expressed in denying the motion. That there was little and no discovery, which was completely irrelevant to this case. There was no discovery that was at issue,
Well, I
or
think that both ways.
and then secondarily, that the binding or unsettled effect of the law. But the fact of the matter is, Your Honor, I certainly am not educating this court. The idea of Pardo is that these cases are set. We are bound to follow them.
That goes to my other point, you know. I mean, I understand all the arguments you're making, but if that was the case, I mean, you cite part of everyone knows that you have to follow line of precedent. But just because of the binding, if that was into the question, you would never, there wouldn't be any discretion. Hey, you won because I had to follow the binding law that's on your side, therefore you could never have that thing. I mean, maybe I'm not making myself clear.
You could never have a reasonable foundation for making the offer. Again,
It's unreasonable.
well, or an unreasonable.
You know, because, I mean, I just want to say that part of your argument, I'm having trouble with, to say, because it was bound by binding precedent, therefore, there can the reasonable basis for the offer, not just winning, it's the offer could never be assailable.
And that was the premise of my argument, because that was the reason that the court expressed in saying that they concluded that it was not made in good faith. The fact of the matter is,
Which gets again to the dilemma of all this case law that seems to be speaking out of both sides of the court's mouth. One is a reasonable basis for the offer. If you have a reasonable basis, then I have no liability, then therefore that would be met. You have good faith to say I have no liability. It's the case we win. But if there is some wiggle room on what good faith means, which is to say, there are also case laws saying, well, if it can be ascertained by the trial court who has discretion that the offering party was just trying to set itself up for fees and it really and did not take into consideration there was some doubt on the ultimate merits, then why couldn't they say, well, isn't there something more than just whether you think you have zero liability?
there is not a single case in the state of Florida that I could identify that would allow for the reasoning for this court to express its use of discretion in the manner that it did. And I can point to cases that equate the idea of granting summary judgment in a nominal offer in an insurance contract case is a good faith basis for making that nominal offer. The Citizens Property versus Perez case, that was a case where there was a nominal offer made and it was based upon an assessment that The insured did not report the alleged damage to his home for nearly 4 years after the fact. So there's a late reporting issue. And the Fourth District Court of Appeal in that case reversed and said on this contractual issue, the insurer stepped back and said, we looked at our contract. We think we did the right thing. We've got a great defense. We're going to give you the opportunity to settle for this nominal amount and avoid the entire purpose of 768.79, which with no fault insurers, frankly, in the state of Florida need the benefit of, and to protect themselves from lawsuits that may not have merit, so that they can give an opportunity for the plaintiffs to make a decision about whether it's a good idea to continue to go forward. And the second case I cited in the brief on that principle is State Farm versus Laughlin Alfonso. And then that was a case with a failure to satisfy pre-suit requirements and submitting sworn proofs of loss. And the Third District Court said, we're going to reverse again. It is an abuse of discretion when an insurance company sits back, looks at their policy, looks at the facts and says, we're going to win this thing. And that's what Progressive did here. They sat back, they looked at the facts, they looked at the policy, they looked at the law, they said, we're going to win this thing. We're going to give you an opportunity to accept $1 for the benefits and $49 for the attorney's fees, granted a nominal amount. But the case at issue, correspondingly, somewhere around $300 allegedly were at issue. So, 50 to 300, the shoe's on the other foot, isn't it?
A way of making another argument, which is that you did split the baby.
Well, and yes, and it's also making the argument that, sometimes you shouldn't just hang on to this case hoping that you're going to win, so that 627.428 is going to result in an attorney's fee to you.
Mr. Clark, let me interrupt you. We've been peppering you. You've used about 17 minutes.
Okay, I'm going to reserve the remainder for rebuttal.
Okay, very well. Thank you. Counsel?
Good afternoon, Your Honors, Counsel. May it please the court. I just want to start off by saying it's nice to be back in the workplace again, and in front of, it's an honor to be in front of you all. I don't know that I'm going to use my whole 20 minutes on this. I don't really have a whole lot to say. I think the court understands our position of abusive discretion on this, just judged based on the questions that were going on before. I mean, that's our argument, is that.
Why does an offering party need to split the baby if under prevailing case law, they believe they have under prevailing case law, they have no liability? Is there a policy argument? Is there a reason on the language of 76879? Where you have to try to take a few steps toward the other party's position if you think their other party's position is absolutely lacking merit?
If they're saying the total exposure was $300 and we're here right now, why they didn't just pay that $300 and be done with it?
Well, that actually then speaks to the fact that we don't even have to determine my kind of, esoteric policy question about, or I should say more, philosophical policy question about whether you need to split the baby. Because you're just emphasizing that they did split the baby. $50 is, I'm not very good at math, but what percentage of 300? It's a pretty high percentage, 1/6.
Right.
You take steps towards your client. So why is that?
Well, that certainly $300 wouldn't be the whole value of the claim, right? Because there's still the attorney's fees part of it. If we're just talking about $300.
It's $1 for that. All right.
Well, just dissuade me from this position that this order may have been different if the offer was more. It was $300, for.
I think that's just a factor. The nominal nature of the offer is a factor.
Judge George made an interesting reference to conflicting opinions in this circuit, and yet he ruled in summary judgment that MRI Tampa was on point, as they used to call cow. 4 legs.
Yeah, totally agreed that on the face this seems incongruous, right? That she would ultimately, and Devin George is a lady. Your Honor, just so just so Your Honor is aware that that would be confusing,
Our first candidate.
yeah, and again, the PIP nature and the extended jurisdiction of this court, this isn't something necessarily that is the regular thing that's here, but yeah, but the offer, but what appellant is asking you guys to do is to take away the reasonable person standard, right? That no other reasonable person could have agreed with Judge George. I mean, the language is clear. Discretion is abused only where no reasonable
So
man.
it's very deferential review, but aren't there cases cited by the appellant in which, under that standard review, appellate courts have said, hey, trial court judge, you abused discretion by drawing the conclusion that this was in bad faith merely because it was nominal offer. So what distinguishes those cases in which appellate courts have reversed based on the abuse of discretion in this case?
Well, I'll go right to Brandonberry as the one coming out of this particular court. In that case, there wasn't a nominal offer, right? There was a substantial offer, a six-figure settlement offer. That was done after, and it was a trial award that was ultimately done, not a motion for summary judgment. This was a jury award that ultimately came back. So discovery, that was a personal injury case. We're talking about a PIP case. So they're just on Brandonberry. There are a number of distinguishing factors, I think, that suggest that the reasonable standard was that a judge could find bad faith. In the other way, there's no finding of there could never be bad faith.
Okay, so we know what the judge did here, though. The judge inferred. Okay, so the judge based it on the fact that the issue that some scintilla of doubt had been cast on this issue because the Supreme Court had taken up our case.
Yes,
So
MRI Associates, State Farm versus MRI
right.
Associates.
So it essentially said you can't. The judge said, well, it's ipso facto bad faith if your offer was nominal and there was some tiny fall of a doubt about whether sometime in the future the law that this court was bound to follow may be overturned.
If we look at the timing of this, our statement of claim came out after that. MRI Associates was ruled on, then the proposal for, the summary judgment followed after that and so forth, right? So when the case was first, I mean, this was good. And it's interesting to me that one day we've got a valid case, a real contention, right? On whether or not, the election of fee schedule was appropriate. And then the next day our case is, completely valueless, right? That just doesn't seem.
Is that the chronology, and then thereafter the summary judgment was filed, and then thereafter there was. So in other words, the chronology is these cases were known to the offeree at the time of the offer, right?
I wouldn't disagree with that. That's right. MRI Associates had
You just said one day your case had some merit, and the next day.
when we filed our statement
Right,
of
so
claims.
at the time you received the offer, it was valueless.
According to this court, I mean, yeah, essentially, I think that that's the ultimate conclusion that the trial court came up with.
So in other words, you said, but according to this court, your case was valueless at the time you received the offer, and we're reviewing a court exercising its discretion to say that because the Supreme Court granted review, or at least didn't outright dismiss the petition, that it's bad faith.
I think that the trial
Bad
court.
faith, when is the bad faith should be assessed, by the way? At the time, it was, when did the Supreme Court, pardon me for forgetting the procedural chronology. When did the Supreme Court grant review?
I couldn't be with any type of.
Before or after the offer was made?
After, sir, I believe.
Okay, so if that's the chronology, At the time this offer was made, you just said your case was valueless.
According to,
To the law.
right, that had just come out. That's
So
exactly
at
right.
the time the offer was made, your claim was valueless. But why does a defendant have to split the baby if at the time it makes the offer, the plaintiff's case is valueless?
Because they don't know that at the time, sir. I don't think that's absolutely knowable at that particular time. Absolutely, you know, given the record, and that's, I think we're getting away from whether or not it's reasonable that Judge George found no reasonable foundation to make this offer, meaning that you can't just rely as a defendant that a case law comes out and say, I got it in my back pocket just based on this alone.
Never rely on it.
I mean, I think it would. I mean, I think it's imprudent, right? To just take a piece of case law and then go to your client and say, it's in my back pocket, it's a done deal. Because you can't anticipate everything. Now, it wound up panning out in this case, right? I mean, but without, it's a tantamount to a bet, placing a bet and your horse coming in.
Who's making the bet? The defendant?
That's right.
And isn't the plaintiff also making the bet that they're gonna somehow throw a Hail Mary and the now prevailing and binding case law is not going to defeat them?
That's, I mean,
And isn't that one of the potential or perceived purposes of the statute to illuminate the party's position so that a plaintiff can decide whether it wants to go forward and incur fees?
I think the purpose of the statute is to encourage settlement. And I think $50 is a hard way to do that. I think that's the heart of the proposal for settlement statute, right? I mean, this is plain language stuff, settlement, proposal for settlement. It's not proposal to dismiss your case, right? I mean, I totally understand the court's position that in counsel's position that it's to take a good look at it. But I mean, in this specific instance, the truncated time period with which the case law came out and the fact that there was little to no investigation aside from case law coming out.
Correct me if I'm wrong, wasn't this based on language of notice and policy and then whether it was adequate under the case law, and that was enough to justify election of the statutory caps?
I'm sorry, Robert, the base statement of the claim?
Yeah,
Yes, that's right.
so what would have needed to be fleshed out in litigation in order for the plan
To see if that, I mean, and it wound up being the case here, and I don't know the specifics of the underlying, sir, but, you know, I didn't argue that, and I'm not trying to lean on that as a crutch in any way, but.
well, if I'm incorrect in the way I characterize it,
No, I think you're right. I think you're right, sir. So I mean, that's the crux of my argument, Your Honors, is that Judge George did not abuse her discretion, and that to hold otherwise is to throw the reasonable judge standard out the window, that no other judge could have found that there was bad faith in a scenario under these circumstances. In the Brandonberry case, there were specific findings on the record as to why the judge found, you know, the reasonableness on the record as to why the proposal was made, and then reversed on completely different reasons. In this case, we have the judge finding on the record why they believed it was unreasonable, even though they ultimately agreed in the end with the argument. So Judge Sleet, I totally understand the incongruous nature of kind of what I'm positing here. I totally understand that, but I just don't think that you could legitimately say that no other judge would find that there was bad faith in the making of this particular nominal offer, especially given the timing.
very good.
Thank you, sir. Clark?
Thank you, may it please the court. Just to clear up a couple issues on the chronology. The Markley case was decided in 2016. Temper MRI Associates was decided in 2018, May 2018, before the proposal. The appendix shows that the Florida Supreme Court issued that order on discretionary jurisdiction on July 17th. All those things occurred before the proposal was
So
served.
so at the time of proposal, the offeror knew that Supreme Court.
Yeah, and all that is established law at that point. Secondly, the idea that at the time that the case was filed, should be evaluated from merit of other law, that there is a virtual imaging case that was decided back in 2013 that makes a very clear distinguishing about the amendment to the statute in 2012, adding 5A5, which just imposes a simple notice requirement, which changes the standard, which the provider should certainly have known about when they filed this case. The next thing on the abuse of discretion standard, which I think the court is concerned about, no reasonable judge. The fact of the matter is there's still a quantum of competent substantial evidence when you're discussing whether there is a reasonable foundation for making that nominal offer. Progressive went to the extreme measure of filing an affidavit on the rehearing after the denial of the motion, where the handling adjuster, the same affiant who supported the motion for summary judgment, explained the basis for making the offer. The only evidence that existed in the record was those statements as to why that offer was made in the manner that it did. So you have facts here that show, and case law that shows that if an insurer evaluates no exposure under a policy, nominal offers are made in good faith. And the reversals are out there, and they're in the brief. And the last thing I will say is, we're undermining the purpose of the statute if we allow for a rule of law for the trial court to, and I don't agree that the law is unsettled. The supplemental authority that I filed last week before this court and contained a case from the 4th District Court of Appeal where they relied upon Amari Associates in reaching their conclusion. The law is settled. Simple notice carries the day. And we ask that you reverse as an abuse of discretion and fulfill the purpose of the statute.
Very good, thank you both. That concludes our docket.